Welcome to our video series, Data Act Unlocked. In this series, we provide a concise overview of the most important provisions of the EU Data Act. In this episode, we will take a look at international data transfers. In particular, we will cover the provisions of the EU Data Act regarding international governmental access to data. Cloud service providers face important new obligations for switching the provider, which we have already covered in Chapter 6 of our video series. Additionally, Chapter 7 of the EU Data Act contains provisions on the transfer of data to third countries outside the European Union. Cloud service providers shall take adequate measures to prevent the transfer of non-personal data stored in the European Union to third country government authorities outside the European Union. A third country data transfer shall be prevented if the transfer does not comply with Union law or the national law of an EU member state. If the cloud service provider receives a request for transfer, it shall inform the customer whose data is affected by the request in advance. Thus, the EU Data Act addresses a difficult issue. If a cloud service provider in the EU is requested by a foreign court or authority to transfer data, the question arises as to whether this request can be complied with without violating Union law. The EU Data Act requires that the cloud service provider may only transfer the data if the request for transfer is recognized on the basis of an international agreement. Therefore, cloud service providers who are requested to transfer data will have to check whether an international agreement permits the transfer of data. If there is no international agreement, data access may no longer be granted without further ado in response to a foreign court decision against the cloud service provider requiring the transfer of data. Before complying with the decision, the cloud service provider must then check whether sufficient constitutional requirements are met in the third country. For example, with regard to the right to a fair hearing and the specificity and proportionality of a decision. For cloud service providers, this could lead to difficulties in the future in regard to demarcation. On the one hand, providers must comply with Union law. On the other hand, providers may be subject to third country regulations that are not comparable to those in the European Union. In this dilemma, the EU Data Act does not require absolute priority for Union law. However, it prohibits cloud service providers from transferring data to third countries if minimum standards of the rule of law are not met in the third country. To help cloud service providers in this situation, they can seek the opinion of the competent national authority. This authority, in turn, has the option of consulting the European Commission. To wrap up, here are the key takeaways from this episode of our new series, Data Act Unlocked. Cloud service providers must take adequate technical, organizational, and legal measures to prevent third country governmental access to non-personal data stored in the European Union. A data transfer is only allowed on the basis of an international agreement or if certain minimum standards are met in the third country. The affected customer shall be informed in advance about the request to access their data. We're glad to have you following our series Data Act Unlocked. For more insights, check out #DataLaw or visit our website.